Hi guys, this is Asal. I'm studying for the bar and I wanted to review my notes with you. Today I'm studying professional responsibility and I'll be reviewing attorney-client privilege and the work product doctrine. I hope you enjoy this. Standing to assert privilege, the holder of privilege or an authorized person on the holder's behalf. Nature and purpose of evidentiary privilege. Privileges. Privileges are basically policy rules of exclusion. Confidential relation privileges include non-relation privileges include. In this video, I'll be talking about the purpose of the privilege, breaking the privilege, and also elements of the privilege. First of all, I'll be talking about the purpose of the privilege. The attorney-client privilege protects the communication between a lawyer and a client and ensures they're confidential, and the attorney-client privilege encourages clients to speak openly so that the lawyers can give them good advice. What are the elements of the attorney-client privilege? The elements are the client, so there must be a client or a prospective client. There must be a communication with the bar or the court, and acting as an attorney for communication. And finally, it must be for the purpose of getting legal advice. So, how do you go about breaking this privilege? You break this privilege when the communication is disclosed to others, intentionally disclosed, or made in the presence of others, or when the communication is made to commit some sort of a crime or some sort of a tort, or the client basically goes ahead and waives it altogether. So, to summarize real quickly the attorney-client privilege, I would like to let you know that this is to encourage frank communication, and it protects those communications that are between a client and a lawyer while acting as a lawyer and to obtain legal advice. And finally, the privilege is broken when the communication is disclosed to others and the communication is made to commit a tort or a crime, or the client waives the privilege. The next thing I'll be talking about is the work product doctrine. So, I'll be talking about the purpose of the work product doctrine, its elements, and overcoming the work product doctrine. And finally, I'll talk about the Federal Rules of Civil Procedure 26b3. So, what is the purpose of a work product doctrine? Under the work product doctrine, documents prepared or compiled in anticipation of litigation are not discoverable. This heightened protection encourages lawyers to document their strategy and compile evidence without fear of disclosure to the opponent. What is the work product exactly? So I'm going to go ahead and give you a little bit of what it is to summarize real quick. It is prepared by the attorney, for the attorney, and also you want to look at the timing with an eye towards the litigation, okay? So it has to be towards the litigation. And how do you go ahead and overcome this work product protection? So you can overcome this when only obtained through discovery, indispensable for impeaching, and finally indispensable for substantiating. Finally, I'd like to mention the Federal Rules of Civil Procedure 26b3, which reflects the work product doctrine. This is about the documents and tangible things, and also it talks about what I mean by anticipation of litigation. And it is discoverable if otherwise discoverable, necessary, and cannot get info without undue hardship. So, to summarize, I just talked about the attorney-client privilege and the work product doctrine, which protects evidence of lawyers that is made for a trial preparation. And I also talked about the elements of the work product doctrine, which is tangible or intangible, prepared by or for the lawyer, and finally in anticipation of litigation. I really hope you enjoyed this. Good luck studying and keep safe and healthy.